You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Legal analysis in privacy requires more than memorizing statutes. It demands a structured method for determining which laws apply, who can enforce them, and where disputes may be heard. Jurisdiction, scope, preemption, and private rights of action form the four cornerstones of this analysis. Each concept provides a lens through which to evaluate legal problems, from identifying whether a court can hear a case to deciding if a plaintiff has standing to sue. Together, these tools create the framework that allows practitioners to navigate overlapping and sometimes conflicting privacy laws in the United States. For exam candidates, mastery of these analytical categories ensures that reasoning remains disciplined and systematic, transforming complex scenarios into manageable steps. These tools not only support exam performance but also mirror the real-world decision-making processes used by privacy professionals and litigators. Subject matter jurisdiction determines whether a court has authority to hear a particular type of case. Federal courts hear cases involving federal statutes, constitutional claims, and disputes between citizens of different states when the stakes exceed statutory thresholds. State courts retain broad jurisdiction over state privacy laws and common law claims. For exam purposes, candidates should remember that jurisdiction cannot be waived. If a court lacks subject matter jurisdiction, the case must be dismissed. This principle ensures that disputes are heard in the correct forum, whether it is a federal court interpreting HIPAA preemption or a state court enforcing a biometric privacy statute. Recognizing the proper forum is the first step in analyzing any privacy dispute, as it dictates the rules, procedures, and potential remedies available. Personal jurisdiction addresses whether a court can exercise authority over a defendant. In privacy litigation, this often turns on minimum contacts. Has the organization purposefully directed activities at the forum state, such as processing resident data or offering services? For example, a company headquartered in New York but collecting data from California residents may be subject to California jurisdiction. Courts consider fairness and foreseeability, ensuring defendants are not hauled into remote courts without meaningful ties. For exam candidates, the key term is minimum contacts, reflecting constitutional due process standards. Scenarios may test whether an organization's online activities create sufficient nexus with a state, highlighting how digital operations complicate traditional jurisdictional analysis. Territorial reach and extraterritorial application are particularly important in state privacy statutes. Many laws, such as California's CPRA, apply to businesses outside the state if they process data about state residents and meet certain thresholds. This creates obligations that extend beyond geographic borders, a concept central to modern privacy governance. For learners, the key term is extraterritoriality, reflecting that obligations follow the data subjects, not the company's location. On the exam, scenarios may describe an out-of-state business and test whether state privacy law applies. Recognizing extraterritorial reach ensures accurate compliance analysis, reminding candidates that in the digital economy, privacy obligations often transcend traditional boundaries. Choice of law becomes critical when disputes span multiple jurisdictions. Courts must decide which state's law governs a contract or claim. Often, contracts specify governing law, but courts may override provisions if they conflict with public policy. In privacy disputes, choice of law questions arise when consumers from multiple states are affected by a breach or data practice. For exam purposes, candidates should recognize that choice of law analysis balances party agreements, state interests, and fairness. Scenarios may ask whether a company can rely on its home state law to govern disputes, or whether the law of the state where consumers reside applies instead. Understanding this concept helps resolve complex, multi-state disputes fairly and predictably. Venue selection and forum nonconvenience further shape where privacy litigation occurs. Venue rules identify the appropriate location within a jurisdiction, often where defendants reside, or where events occurred. Forum nonconvenience allows courts to dismiss cases better suited for another location, especially in cross-border disputes. For exam candidates, the key terms are venue and convenience. Exam questions may test recognition of whether a case is filed in the correct venue or whether dismissal is appropriate due to burdens on the parties. This concept reinforces that litigation is not only about which laws apply, but also about where disputes are most fairly and efficiently resolved. Standing requires plaintiffs to demonstrate injury in fact, causation, and redressability. In privacy cases, standing often hinges on whether intangible harms, such as loss of control over data or increased risk of identity theft, qualify as concrete injuries. Courts vary in their interpretations, with some requiring actual misuse of data and others accepting exposure to heightened risk. For exam purposes, the key term is injury in fact, reflecting the constitutional threshold for private litigation in federal courts. Scenarios may test whether a plaintiff has sufficient standing to sue under statutes like BPA or the VPPA. Understanding standing ensures candidates can assess whether litigation is viable, not just whether a violation occurred. Applicability thresholds define whether state statutes apply based on factors like revenue, data volume, or resident counts. For example, California's CPRA applies to businesses with annual revenues over $25 million, or those processing personal data of over 100,000 residents. These thresholds focus obligations on larger or more data-intensive organizations. For learners, the key idea is that applicability is not universal. Compliance begins with determining whether thresholds are met. Exam questions may test recognition of these thresholds, ensuring candidates understand that obligations hinge on both activity and scale. This concept highlights the tailored design of modern state privacy laws, which aim to regulate significant players while sparing small businesses. Exemptions further refine statutory scope. Entity-level exemptions may exclude nonprofits or government agencies, while data-level exemptions remove categories already governed by federal law, such as HIPAA-protected health information. These carve-outs prevent duplication and conflicting obligations. For exam candidates, recognizing exemptions is critical, as scenarios may describe an organization or data type outside statutory reach. The key terms are entity level and data level, each signaling a different type of exclusion. Understanding exemptions ensures candidates can quickly assess whether obligations apply or whether another legal framework governs instead. Definitions of personal information and sensitive data also shape applicability. Personal information often includes identifiers like names, addresses, or online IDs, while sensitive data covers categories such as biometrics, health, or precise geolocation. These definitions vary by statute and directly affect obligations such as consent or enhanced safeguards. For exam purposes, mastering these definitions is essential, as questions often test whether described data qualifies as personal or sensitive. This reinforces that legal analysis begins not with assumptions but with careful reading of statutory definitions, which form the gateway to compliance. Controller and processor roles define responsibilities within statutory frameworks. Controllers determine purposes and means of processing, while processors act only on instructions. These roles allocate accountability and often determine who must respond to consumer rights requests. On the exam, scenarios may test whether a company is a controller or processor and what obligations attach. For learners, remembering these distinctions is crucial, as misclassifying roles can lead to noncompliance. This concept also reflects how U.S. laws increasingly align with international frameworks like the GDPR, creating consistency in global privacy governance. Household and employment-related data carve-outs appear in many state laws, excluding certain categories from coverage. For example, some laws exclude employee data from consumer rights provisions, reflecting different policy balances in workplace contexts. Household exemptions may narrow the definition of personal data to focus on individuals rather than aggregated family use. For exam purposes, recognizing carve-outs ensures accurate scope analysis. Scenarios may test whether employment records fall under consumer privacy statutes or whether household-level data triggers obligations. These exclusions illustrate how statutes refine applicability to avoid unintended burdens while preserving core protections. Nonprofit and small business exemptions are another common feature. Many state laws exclude nonprofits entirely or exempt businesses under certain revenue thresholds. These exemptions reflect policy choices to balance consumer rights with economic feasibility. For learners, the key terms are nonprofit and small business carve-outs. Exam scenarios may test whether an organization qualifies for an exemption, emphasizing that applicability analysis requires careful attention to both statutory language and organizational structure. These provisions demonstrate that privacy law aims not only for protection, but also for proportionality in regulatory impact. Government and sector-specific exclusions further narrow coverage. Some state statutes exclude government agencies, while others defer to existing federal frameworks for specific sectors like financial or health data. For exam candidates, recognizing these exclusions ensures clarity in analyzing scope. Scenarios may test whether state laws apply to government entities, or whether federal laws preempt obligations in specific sectors. This reinforces the broader theme that privacy governance is fragmented, with overlapping and sometimes exclusive regimes shaping organizational responsibilities. Preemption doctrines, including express, field, and conflict preemption, provide the tools for resolving clashes between federal and state privacy laws. Express preemption arises when Congress explicitly states that federal law overrides state law. Field preemption occurs when federal regulation is so comprehensive that it occupies the entire field. Conflict preemption applies when compliance with both federal and state laws is impossible. For exam purposes, candidates should master these distinctions, as scenarios often describe overlapping obligations. Recognizing which type of preemption applies ensures accurate analysis of which law governs. This concept reflects the delicate balance between national uniformity and state-level innovation. Preemption safe harbors and state police power carve-outs illustrate that even when federal law preempts broadly, states may retain authority to legislate in certain areas. For example, states often maintain power to regulate unfair business practices under their police powers, even in fields with significant federal oversight. For learners, the key terms are safe harbor and police power. Exam questions may test whether state authority survives despite broad federal regulation. This concept underscores the layered nature of U.S. law, where federal supremacy coexists with residual state authority to protect residents' welfare, often through privacy and consumer protection statutes. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. HIPAA Preemption offers a clear example of how federal and state privacy laws interact. HIPAA establishes national standards for health information but allows state laws to remain in force if they provide stronger protections. This creates a floor rather than a ceiling, ensuring that federal requirements apply everywhere while preserving room for states to innovate. For exam purposes, candidates should remember the concept of more stringent provisions, meaning that state laws survive if they enhance individual rights or tighten safeguards. Scenarios may test whether a state health privacy statute is preempted or whether it coexists alongside HIPAA. This framework illustrates how federal law shapes uniformity while still enabling states to address local needs and policy preferences, reinforcing the patchwork nature of privacy compliance. The Gramm-Leach-Bliley Act creates another layer of preemption complexity in financial privacy. GLBA establishes requirements for privacy notices and safeguards, but does not completely eliminate state authority. State financial privacy laws may continue to apply if they do not conflict directly with GLBA, and some states have adopted stricter standards. For learners, the key point is that GLBA preemption is limited, leaving space for state regulators to impose additional requirements. On the exam, scenarios may describe financial institutions subject to both federal GLBA rules and state-level mandates, requiring candidates to analyze whether obligations coexist or whether federal law displaces state provisions. This highlights the nuanced interplay between federal baselines and state enhancements. The Fair Credit Reporting Act demonstrates more explicit preemption. FCRA includes specific provisions that override inconsistent state requirements in areas such as reporting accuracy and dispute processes. However, it also contains exceptions, allowing states to legislate in areas not expressly covered. For candidates, the critical terms are explicit preemption and exceptions. Exam questions may test whether a particular state law governing credit reporting survives under FCRA's framework. Understanding this balance ensures accurate application of preemption analysis, showing how federal law can create uniformity in certain areas while still allowing state-level diversity in others. COPPA illustrates coexistence boundaries between federal and state laws. While COPPA governs online collection of children's data, it does not completely block state enforcement or additional obligations. States may act under their own consumer protection laws to address practices involving children, provided they do not contradict COPPA's framework. For exam purposes, candidates should recognize that COPPA sets a national baseline for children's online privacy, while still leaving states authority to act in complementary ways. Scenarios may test whether state-level enforcement is permissible or preempted, requiring learners to analyze the relationship between federal statute and state police powers. The Telephone Consumer Protection Act introduces another layer of preemption dynamics. TCPA regulates telemarketing calls, text messages, and faxes, but states may impose stricter rules. This creates a dual structure where businesses must comply with both federal and state telemarketing restrictions. For candidates, the important concept is coexistence with stricter state rules. On the exam, scenarios may describe state laws prohibiting practices that federal law allows, testing whether candidates recognize that state authority remains valid. This demonstrates how preemption analysis requires attention not only to explicit statutory language, but also to the degree of flexibility granted to states. Private rights of action add a different dimension to legal analysis. The Video Privacy Protection Act provides consumers with the ability to sue directly for violations, including statutory damages. For exam purposes, the key terms are damages framework and direct enforcement. Scenarios may test whether plaintiffs have standing under VPPA or what remedies are available. The existence of statutory damages reduces the burden of proving harm, making VPPA a powerful tool for private enforcement. This illustrates how federal law sometimes supplements regulatory enforcement with individual litigation, increasing compliance risks for organizations. Illinois' Biometric Information Privacy Act has become a landmark state statute due to its private right of action. BIPA allows individuals to sue for violations without showing traditional injury, relying instead on statutory violations as sufficient harm. Courts have upheld broad standing under this law, leading to large settlements and class actions. For learners, the key concept is standing implications, as BIPA lowers barriers for plaintiffs compared to other privacy statutes. On the exam, questions may test whether a scenario involving biometric data triggers private litigation rights, emphasizing how statutory design influences enforcement dynamics. BIPA demonstrates the powerful role of state statutes in shaping national compliance priorities. California's CCPA and CPRA illustrate a hybrid model. While enforcement authority lies primarily with the California Privacy Protection Agency and the Attorney General, a limited private right of action exists for certain data breaches. Consumers may sue when their non-encrypted, non-redacted personal data is exposed due to inadequate security. For exam purposes, the important idea is limited scope. Not all violations of CCPA or CPRA support private lawsuits. Scenarios may test whether a breach falls within this narrow right, requiring careful analysis of statutory language. This example highlights how states experiment with balancing public and private enforcement mechanisms. State breach notification statutes vary widely in their private right provisions. Some allow individuals to sue for damages when notice obligations are violated, while others restrict enforcement to regulators. Remedies may include statutory damages, actual damages, or injunctive relief. For candidates, recognizing variability is essential. The presence or absence of a private right differs across states. Exam scenarios may describe a breach and test whether consumers can enforce rights directly. This reinforces that privacy compliance requires not only technical safeguards but also awareness of litigation exposure under state-specific frameworks. Unfair and deceptive acts and practices statutes at the state level often include private enforcement mechanisms. Consumers may bring lawsuits under these statutes for deceptive privacy practices, such as misleading notices or unauthorized data sharing. For exam candidates, the key terms are statutory private actions and consumer protection overlap. Scenarios may test whether deceptive practices are enforceable under state UDAP laws, even when no specific privacy statute applies. This highlights the flexibility of consumer protection frameworks, which serve as catch-all mechanisms for enforcing privacy, fairness, and transparency. Contracts also create private enforcement rights. Data processing agreements often include indemnification clauses, allowing one party to recover losses if the other fails to meet privacy obligations. These contractual rights operate independently of statutory frameworks, providing another avenue for remedy. For learners, the key idea is that private enforcement can arise through contract, not just statute. On the exam, scenarios may describe vendor relationships and test whether contractual terms provide enforceable rights. Recognizing contracts as private law instruments ensures a complete understanding of enforcement options in privacy disputes. Arbitration clauses and class action waivers often appear in privacy-related contracts, shaping how disputes are resolved. These provisions may limit plaintiffs to individual arbitration rather than collective litigation, reducing exposure for organizations. For candidates, the key terms are arbitration and waiver. Exam questions may test whether such clauses are enforceable, particularly in the context of statutory rights. Understanding these mechanisms highlights how organizations manage litigation risk contractually, complementing statutory analysis with private dispute resolution structures. Remedies and damages typologies also shape the enforcement landscape. Statutory damages provide fixed amounts regardless of actual harm. Actual damages compensate measurable losses, and injunctive relief orders organizations to change practices. For learners, recognizing these categories clarifies the stakes in privacy litigation. On the exam, scenarios may test which remedy applies under a given statute. Understanding the range of remedies ensures candidates can analyze litigation exposure comprehensively, linking legal violations to practical consequences. Declaratory judgment actions allow organizations to seek court rulings on whether their practices comply with the law before enforcement or litigation arises. This proactive tool provides clarity but requires judicial willingness to hear abstract disputes. For exam candidates, the key concept is compliance determination. Scenarios may test whether declaratory relief is available in a given case. Recognizing this mechanism reinforces that privacy litigation is not only reactive but can also be preventative, providing organizations with legal certainty in uncertain regulatory environments. Litigation risk assessment ties all these analytical tools together. Organizations must evaluate jurisdictional exposure, scope of applicability, preemption dynamics, and private litigation risk when designing privacy programs. For exam purposes, the key term is risk assessment, signaling that compliance strategies must anticipate not only regulatory enforcement but also potential lawsuits. Scenarios may test whether a company has adequately accounted for litigation risks in its program design. This reinforces the practical reality that privacy compliance is not just about meeting statutory requirements, but also about managing the legal risks of operating in a fragmented and evolving enforcement landscape. By mastering jurisdiction, scope, preemption, and private rights of action, candidates gain the tools to analyze complex legal scenarios systematically. These concepts form the analytical core of exam reasoning and the practical foundation of compliance strategies, ensuring that privacy professionals can navigate overlapping frameworks with clarity and confidence. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.